The transgender movement boils down to a question of subjective versus objective. If someone believes they are not the gender they were born, is the problem with their body or with their mind? This is the fundamental question, and by extension, the fundamental issue which society is being asked to decide. In the middle of this, the Biden administration has created its own moral quandary, revolving around the question of subjective versus objective. Does a law mean what the language objectively says, or does it mean what a person subjectively wants it to mean? That question is what the case State of Tennessee et al. Versus Miguel Cardona et al. Is all about. From the injunction, we read, this case concerns an attempt by the executive branch to dramatically alter the purpose and meaning of Title IX through rulemaking. But 6 states, an association of Christian educators, and one 15-year-old girl object. As they correctly argue, the new rule contravenes the plain text of Title IX by reading sex to include gender identity, violates government employees' First Amendment rights, and is the result of arbitrary and capricious rulemaking. If the new rule is allowed to take effect on August 1st, 2024, all plaintiffs will suffer immediate and irreparable harm. This case revolves around Title IX of the Education Amendments Act, signed into law by then-President Richard Nixon on June 23, 1772. The law states, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. While the law does provide some exceptions, for the most part, any education program or activity receiving federal financial assistance is barred from excluding people from participation in or the benefits of an education program or activity based on their sex. In 1974, Congress passed an amendment to Title IX introduced by Senator Jacob Javits of New York, clarifying its application to intercollegiate athletics. The amendment directed the Department of Health, Education, and Welfare, the Department of Education's predecessor, to issue a regulation that contained, with respect to intercollegiate athletic activities, reasonable provisions considering the nature of a particular sport. Notably, this amendment further cemented that Congress intended Title IX to cover athletics at all levels for both males and females at schools receiving federal funding.